about refugees and refugee policies in Japan and the UK. And I will just introduce our chair and then leave it to him to do the rest. So our chair for this evening is Matthew Gibney, who's there. And he is Professor of Politics and Forced Migration at Oxford University. And he's also Director of the Refugee Studies Centre. And he's written lots of books and journal articles. To mention a few, things like The Ethics and Politics of Asylum, Globalizing Rights, Immigration and Asylum. So this whole evening, I hope, will be right up your street, Matthew. And on that note, I'll pass over to you.
Thank you, and welcome everyone to this seminar on refugee policy in Japan and the UK. Let me introduce our two speakers. Our first speaker is going to be Naoko Hashimoto, who is a research associate at the Refugee Law Initiative at the University of London. She has a lot of practical experience, indeed 15 years experience in refugee and forced migration issues, working for the government of Japan, working for UNHCR, IOM in New York, Geneva, Sri Lanka, and Tokyo, sorry. It's late in the day. She has numerous publications on refugee and migration issues, both in English and Japanese, and she's served on many projects as an independent advisor and regularly appears in the media as well. I'm pleased to say, along with some other people here, that she holds a Master's of Studies in Forced Migration from the University of Oxford, which is run by the Refugee Studies Centre, of which I'm director. And I remember Naoko very, very well indeed. And an LLM in International Human Rights Law from the University of London. She is currently writing her PhD thesis at the University of Sussex and analysing why Japan started to admit refugees through resettlement in 2008, which I think is a very interesting question for tonight's presentation. Naoko will be followed by Maurice Wren, who is Chief Executive of the Refugee Council of Britain. And he's been Chief Executive since 2013, having previously worked in the homelessness and refugee protection fields with shelter and asylum aid. He was Director of Asylum Aid for 12 years. Maurice played a pivotal role in co-founding the groundbreaking Independent Asylum Commission in 2007 and the Detention Forum in 2009, and is presently co-chair of the National Asylum Stakeholder Forum at the Home Office and chair of UK Refugee Week, which is coming up. He's a trustee of Migrant Voice, Every Casualty Worldwide, and the European Network on Statelessness, and was made a patron of Action Foundation in 2016. I noticed from his CV also that he was awarded an honorary doctorate by the University of Edinburgh in recognition of his humanitarian work with refugees. And I think everyone in the UK that works on refugee issues is very familiar with Maurice's voice. So we're going to start by looking at the Japanese side of our question, and Naoko is going to lead us off.
Thank you very much, Matthew. It is indeed my great honor and pleasure to be invited to give a talk at the Taiwan Anglo-Japanese Foundation, especially together with such prominent figures like Maurice and Matthew. And as well as, I noticed that there are really high-profile audience, high-profile people in the audience as well. Matthew didn't mention, but kind of implied, but Matthew was the first person who taught me refugee studies some years ago. And as you can imagine, it is really nerve-wracking for me to have to make presentation in front of my first teacher. Matthew is not the only person who taught me refugee studies. Don Chadi, as some of you may know, is here as well. So I'm extremely nervous, but just to give you a caveat, if you happen to find my presentation okay, all the credits should go to Matthew and Don. But if you happen to find my presentation awful, it's all because of my fault, not because of the Refugee Studies Centers in Oxford. So with that caveat, I'd like to talk about Japan's refugee protection policy today. Let me start with my conclusion first, because in 15 minutes you may be bored with my talk. So and my suggestions for take-home message out of my talk today are these. So as some of you may know, there has been a sort of a battle of narratives between the government of Japan and the lawyers and NGOs as to the reasons why Japan recognizes such a small number of refugees among asylum seekers who reach Japan. Both, according to me, both arguments put forward by the Japanese government and the lawyers and NGOs have some pertinent points, and I would like to provide you as much comprehensive and balanced picture as possible. Secondly, all things considered, I think still it is safe to say that a relatively small number of asylum seekers and refugees come to Japan. And therefore, thirdly, if Japan is to share the fair burden and responsibility of international efforts to protect, assist refugees, Japan should expand more resettlement and also establish sort of subsidiary complementary protection scheme, which I'm going to explain for some of you who may not be very familiar with the refugee issues. So, back to the basics. There are mainly three ways for countries in general to join the international efforts to protect and assist refugees. One is to provide asylum for those asylum seekers who spontaneously arrive in your country. Second is, the first one is to provide asylum and also facilitate local integration once the person is recognized as a refugee. And the second is to bring the refugees in, the refugees who are still outside of your country through resettlement. And Maurice is going to probably talk about this, but for example, David Cameron, 2015, committed to resettle 25,000 Syrian refugees who are still in Turkey, Lebanon, Jordan. And also, the Japanese government, as Matthew mentioned in my introduction, Japanese government also decided to start visiting Myanmar refugees who are still in Thailand or Malaysia. The third way is to provide financial contributions, either bilaterally to the governments that host of the countries that host large number of refugees, or multilaterally to the international organizations that assist refugees. In my talk today, I'm going to mainly talk about the first point and touching upon quickly the second point, but largely ignoring the third point. This does not necessarily mean that the financial contributions are not important. Oftentimes, the value of international, financial contribution is quite trivialized, and as some of you may have heard, Japan is often portrayed as cash machine for UN agencies. But having worked in the field of refugee assistance for UN agencies, I'd like to underline that those financial contributions are actually highly important and appreciated because, to provide emergency humanitarian assistance to those displaced persons, especially because more than 80% of refugees in the world are hosted in less developed countries in the world. So basically, bilateral or multilateral contribution actually makes it possible for the less developed countries to take more open or humanitarian protection policies. Having said that, given the time limit, I would like to move on to the protection side of Japan's refugee policy. Yes, so Japan's refugee protection policy has evolved mainly through three phases. First is the admission of 11,000 Indo-Chinese refugees from the late 90s through early 2000s. This was part of the international efforts to find solutions to the, roughly speaking, 2 million Indo-Chinese refugees. At that time, Japan was not a popular destination country for those refugees, and the Japanese government actually struggled to meet the 11,000 quota. And it is now estimated that more than half of those Indo-Chinese refugees have already left Japan to reunite with their families and relatives in the States, France, Australia, Canada, etc. Having said that, in my opinion, the Indo-Chinese refugee response was the sort of important dawn for the subsequent Japanese refugee protection policy. Second was that in 1981, Japan decided to accede to the Refugee Convention. And since 1982, the Immigration Bureau of the Ministry of Justice has been conducting individual asylum, individual refugee status determination procedures for those asylum seekers spontaneously arriving in Japan. Between 1982 and 2017, roughly speaking, 60,000 asylum seekers made asylum claims in Japan, out of whom the Ministry of Justice recognized 700 refugees. And also this makes the kind of so-called refugee recognition rate about 1.2%. Just to give you some rough idea, for those non-refugee experts, for the recent years, the average international refugee recognition rate is about, roughly speaking, between 25% to 30%. And also the UK government, for example, last year recognized more than 7,000 asylum seekers as conventional refugees, and the US government in 2016 granted more than 20,000 refugee status to the asylees in the States. So you can generally say that 700 refugees during 35 years is a really minuscule number, although I believe that such a simple comparison doesn't necessarily lead us to kind of meaningful discussion, so I would like to come back to the point later on. In addition to those full-fledged refugee recognition, the Ministry of Justice of Japan has given so-called special permission to stay on humanitarian grounds to, roughly speaking, 2,500 asylum seekers in Japan. Also, I'm coming back to this humanitarian grounds permission later on. And thirdly, much to our surprise, the Japanese government decided to launch a refugee resettlement program in 2008. And then that program admits only 30 Myanmar individuals per year from Thailand or Malaysia. And well, basically, for the past 7 years, the average number of world resettlement, the number of world resettlement cases has been about, like, roughly speaking, 70,000 to 100,000. So again, you can say the Japanese resettlement program is really minuscule in terms of quantity. However, in my opinion, the causes and consequences of the resettlement decision were sort of significant in terms of refugee protection policy of Japan. And well, as Matthew said, I'm currently analyzing what led Japan to launch resettlement program, because some observers claim that Japan hates refugees and migrants. This slide shows the asylum and protection statistics since 1978. As you can see, almost nothing was happening in Japan until 2000. And I mean, apart from the admission of the Indo-Chinese refugees, which is shown in the gray line, if those who are sitting at the back can see. The number of both asylum seekers, which is shown in blue line, and also recognized refugees, shown in orange line, was almost nil during 1990s. And that created a kind of international criticism against Japan as being Refugee Seclusion-ism, or Nanmin Sakoku in Japanese. As you can see, the number of asylum applications started to soar from 2005, and the last year it reached almost 20,000. But the number of asylum seekers who got granted the official conventional refugee status by the Japanese government last year was only 20. So again, that made so-called refugee recognition rate to 0.2%. So this has led to another wave of international criticisms. Each article shown here did contain some pertinent points, but in my opinion, none of them provided comprehensive sort of picture as to why Japan recognizes such a small number of refugees. And for the rest of my time, I would like to kind of summarize the kind of rationales put forward by the Japanese government on the one hand, and the criticisms put forward by the lawyers and NGOs in Japan on the other. So let me begin with what the Japanese government has to say. Okay. So rationale number one. Japan, according to the Japanese government, Japan is far away from so-called major refugee-producing countries such as Syria, Iraq, Afghanistan, South Sudan, Somalia, etc. As you can see from this chart, the major countries of origin of the asylum seekers for the past 7 years in Japan were Nepal, the Philippines, Turkey, Vietnam, Sri Lanka, and Indonesia. Last year, almost 5,000 asylum applicants came from the Philippines. If you ask me, I do not necessarily buy the argument put forward by the Japanese government because refugees are refugees, regardless of their country's origin. There's a kind of widespread misunderstanding as if refugees have to come from war-torn or conflict-affected countries. But this is simply just misunderstanding, legally speaking. Because refugees are those who fear persecution, regardless of the conflicts or generalized violence. And for example, I would not be surprised if some of the Filipino asylum seekers in Japan have well-founded fear of extrajudiciary killing due to the current President Duterte's kind of draconian policy, for example. Rationale number two, yes. So the Japanese Immigration Bureau says that the many asylum claims made by asylum seekers in Japan are often based upon private problems such as like quarrels with the neighbors or even love affairs or economic hardships such as debt or poverty. And then I have actually heard that some asylum seekers in Japan actually say that they came to Japan because they wanted to work. And this has a kind of background, there's a background to this phenomenon. In fact, so this is the same statistic as I've shown before, but you can probably notice that there were two kind of timings of increases of asylum applications for the past 2 decades. One is the 2005 and the other is 2010. Yes. So in 2005, the first major revisions to the refugee status determination procedure were introduced in Japan. And the revisions included, one, the abolishment of the 60-day rule in which asylum seekers used to have to apply for asylum within 6 days upon arrival in Japan, but that was abolished. Second, the creation of new provisional stay permit for asylum seekers under some conditions. And the third was the establishment of the so-called refugee examination counselor system, in which some prominent figures like professors, like retired diplomats, prosecutors, lawyers, etc. They are appointed by the Ministry of Justice to review the rejected asylum applications and put forward advisory opinions on individual cases to the Immigration Bureau. I will come back to the problems of this refugee examination counselor system later on. In 2010, the major revision was made in that the asylum seekers who lodge their asylum claim, while they have valid residential status, can work and earn wages if they have to wait for asylum decision longer than 6 months. So this has worked, according to the Japanese government, as a kind of incentive for all those foreigners who have a valid residential status to claim asylum in Japan, regardless of whether or not they actually have well-founded fear of persecution. As you can see, okay, I have to go to the next slide. Yeah, as you can see from this chart, the majority of the asylum seekers enter Japan for the last several years as either temporary visitors, technical interns, or foreign students. Again, I personally believe that it is actually nothing wrong, actually it is good that asylum seekers can reach Japan legally, safely, without having to resort to smugglers. At the same time, the Japanese government says that usually the technical interns and foreign students come to Japan based upon recommendations and logistical assistance provided by the public authorities in the country of origin. So the Japanese government claims that if the same persons can receive public assistance from the government in the country of origin, why the same persons would fear persecution from the same government. So that's the Japanese government says it's slightly inconsistent or puzzling. Yes, and then on this last point, I would have to slightly lean towards the kind of rationale put forward by the Japanese government. And by the way, there's another background to this chart from the general immigration situation in Japan. The number of foreign tourists has started soaring in the recent years because of the government-wide sort of campaign of Yokoso Japan or Visit Japan, under which the visa requirements for some Asian countries have been really relaxed. The same is true to the technical interns because of the Abe administration's sort of policy to expand the sectors in which the technical interns can work because of the lack of labor force in Japan, because of the precipitating aging population, and also lack of labor force in construction, especially because of the forthcoming 2020 Tokyo Olympics and Paralympics. Yes, and yes, I actually don't have another slide, but then let me just explain another kind of rationale put forward by the Japanese government. Many asylum seekers repeat their asylum applications based upon the same claim without having to submit any new evidence or information. Last year, more than 1,500 asylum applications were repeat applications, and some of which were actually sixth application. I understand that Japan is one of the very few countries in the world that allow asylum seekers to repeat applications, asylum applications based upon exactly the same claim, substantive claim. And but at the same time, I also personally believe that it is good that the asylum seekers can have the possibility of repeat applications because wrong decision can mean death for asylum seekers. And particularly also because Japan does not have any superior asylum arbitration or like education entity like European Court of Human Rights. At the same time, it is also concerning that the repeat applications can prolong the list of asylum backlog and thereby kind of delaying the real bona fide refugees to have access to the full protection in Japan. Okay, so these are the kind of main four reasons or rationales put forward by the Japanese government as reasons why Japan can only recognize a very few asylum seekers as refugees. Now, what the lawyers and NGOs have to say. Criticism number one. So the Japanese government interpretation of the notion of persecution is extremely strict. For the Japanese Immigration Bureau and courts, the persecution means, I read out for those who are sitting at the back, for the Japanese government, the persecution means attack or oppression which brings about pain intolerable for ordinary persons, which normally signifies violation or suppression of life or freedom of body. This is actually considerably narrower than the definition taken by other industrialized countries. For instance, according to the Article 9 of the EU Qualification Directive, persecution means sufficiently serious act by its nature or repetition as to constitute a severe violation of human rights, or basic human rights even. So you can see still the Japanese, I mean, so, apology for those who are not lawyers, but then it's really kind of, it's very difficult to understand, at the first look. But anyway, I want to say that the Japanese understanding of persecution is narrower than at least Article 9 of the EU Qualification Directive. Criticism number 2. The Japanese government sets the standard too high for the burden of proof of probabilities or likelihood of persecution. It is generally argued that the Japanese Immigration Bureau or courts do not recognize the benefit of the doubt, and asylum seekers are required to provide proof beyond reasonable doubt for the possibility of their persecution, and which is considerably higher, or this standard, this threshold, usually used in the criminal cases for those who are lawyers here. On the other hand, many other countries set the burden of proof threshold relatively lower or equivalent to the threshold used in civil cases. For example, in the UK, it's the reasonable degree of likelihood, to be persecuted. For the US, that's reasonable possibility. For Canada, that's reasonable chance of persecution. Australia and New Zealand, that's a real chance of persecution. I would have to be sympathetic to this criticism, especially because it is almost impossible for asylum seekers to have collected all the evidentiary materials of their persecutory experience right before the urgent flight, and especially because also usually persecution is conducted in a secrecy manner without any proof of document. Yes, I have persecuted you. That no government would issue such a kind of certificate or something like that. Criticism number 3, that, as I mentioned, the refugee examination counselor system is defunct. It initially started with 20 individuals, but now it is comprised of 90 individuals. And the expertise and experience in the refugee status determination procedure of those refugee examination counselors significantly vary, to say the very least. Also, the system is structured in a way that the examiners, the counselors, are not only independent from the Japanese government, because the Immigration Bureau serves as the secretariat. In addition, the advisory opinions of the counselors are not fully respected in recent years. Because it is statutory speaking, it's not legally binding. It was true until 2012 that all the advisory opinions of the examination counselors were fully respected, and then actually the asylum seekers whose applications were initially rejected got convention status in respect of the positive review made by the examination counselors. However, since 2013, opinions of the examination counselors are less respected, and the Immigration Bureau does not necessarily always revise their denial decision, even if the examiner said that, the counselor said that this person is a refugee. There are actually numerous other kind of technical criticisms, but for the benefit of time, let me move on to that kind of conclusive part. So on balance, I think most of all the rationales put forward by the Japanese government and criticisms by lawyers and NGOs, actually they all have valid points to a certain extent. And I cannot make final judgment here because I don't have any full access to all 20,000 asylum application files. But if you ask me, still I think it is safe to say that Japan receives a relatively smaller number of asylum applications compared to many other industrialized countries. For instance, Japan has never received 890,000 asylum seekers like Germany did in 2015. And it's very unlikely that Japan would receive massive asylum applications, even in the case of Korean Peninsula crisis. I can explain why later on if you have any questions. So Japan is not a popular destination country for those individuals who have well-founded fear of persecution and those who can spontaneously arrive the destination country. So given these kind of constraints and conditions, let me conclude by putting forward 3 kind of proposals or like a food for thought as ways forward for what Japan should do to share the fair burden of the global burden responsibility in the global refugee protection endeavor. One, if the refugees do not come spontaneously, let us bring them in from other countries through resettlement. As I said, the current annual quota of Japanese resettlement program is only 30 individuals per year, which is minuscule in the view of the economic and demographic situation of Japan. Also, the resettlement refugees are selected according to the quite strict restrictive selection criteria, but these criteria should be relaxed in my opinion as well. And in terms of quota, it should be possible to increase at least to a few hundreds per year, in my opinion. Second, establish a subsidiary or complementary protection scheme in addition to the current special permission to stay on humanitarian grounds. In fact, this special permission has allowed, for example, all Syrian asylum seekers in Japan legally and safely, but the criteria for issuing the special permission are kind of discretionary, and therefore even those who flee conflict and arrive in Japan are not automatically entitled to receive this special permission on humanitarian grounds. In terms of assistance, actually, those on humanitarian grounds can already enjoy almost same rights and entitlements as those enjoyed by conventional refugees. However, one big difference is that those on humanitarian grounds cannot access to any public integration assistance, which are usually provided for conventional refugees. And thirdly, this is my last point. Here comes a bit of controversy, and I would very much like to have discussions with experts or with the audience. I am fully aware that I'm aware of the current international attention to the private sponsorship scheme or various humanitarian vision programs in various parts of the world. These are kind of devised, especially in response to the Syrian refugee crisis. But having studied a little bit of the pros and cons of those new initiatives, I'm not yet fully convinced of the merits of those kind of innovative schemes. For example, I have heard from the Canadian researcher that the Canadian model of private sponsorship has led to a certain extent of privatization of public services, abuse or exploitation of refugees, or cherry picking of good and talented refugees, or even sort of resettlement scheme turning into a kind of de facto family unification scheme. In case of Japan, Japanese government decided to accept 150 Syrian refugees as graduate scholarship students to Japanese universities. And it is definitely better than nothing. However, the Syrian refugees with university degree, with English proficiency, are obviously the best and the brightest, or creme de creme. And I do not think such an elitist scheme should be regarded as an excuse for the government not to admit more extremely vulnerable refugees through a more ordinary resettlement program. I think I have used up almost all my time, so let me stop here. Thank you very much for your attention. I don't have any comments.
Thank you now for that wide-ranging and I think incredibly informative account of Japanese refugee policy. And I'm sure there's going to be many questions about it as we go through. Now Morris is going to bring us to the UK.
Good evening, everyone. And can I start by thank you to the Foundation for the invitation to come and speak tonight. It was very gratefully received, and I'm delighted to be here. For those that don't know, my organisation is probably the largest in the UK, providing direct services to refugees and people seeking refugee protection in the UK, and we work at pretty much every point of the asylum and refugee protection journey in the UK. So I'll talk to you tonight of the experience of on one hand, a practitioner, a pretty experienced practitioner. We see a lot and we help a lot of people every year, but also somebody that spends perhaps too much of my time talking to Home Office officials and government ministers. I call myself a stakeholder. They probably regard me as a bit of a bloody nuisance. And when you've heard my remarks, you'll probably begin to appreciate why that is. When discussing UK refugee and asylum policy or practice, government ministers and officials in the UK often refer to our proud history of providing protection to refugees. And indeed, the principle of welcoming refugees to the UK continues to enjoy high levels of political support here, with all the major political parties endorsing our commitment to the Refugee Convention. Public attitude surveys, and in particular I'm referring to the work done by Professor Robert Ford at Manchester, or the work on the national conversation undertaken over the last year by a think tank called British Future, conducted in-depth conversations with communities in 60 locations around the UK. Their findings indicate significant and growing public support for the principle of providing refugee protection. Substantial public resources are expended on the day-to-day operation of the UK asylum system, even though the numbers of people who claim protection here is relatively low, within country applications running at the moment at around 26,000 over the last 12 months. And it's important to note those are applications. Only about 35% of those are actually granted permission refugee protection in the UK. And on top of that, we can add around about 5,000 resettled refugees, which is our current commitment, at least for the next couple of years. We spend a lot of money on providing accommodation around the country, and the Home Office works on the basis of providing 40,000 bed spaces at any one time. We provide welfare support to anybody in the asylum system and maintain a separate bureaucracy. The Home Office runs its own welfare department. It's not part of the mainstream welfare benefit system in the UK. We provide a not insignificant amount of legal aid to people seeking refugee protection. We have a panoply of decision makers at the initial stage and at the appeal stage through the tribunal system. And the Home Office bureaucracy of policy people, country or origin information people is in itself quite a financial commitment. And not only that, the performance of this system is scrutinised by a range of government, parliamentary and civil society actors. We have an independent chief inspector of borders and immigration who regularly undertakes inquiries into the operation of the system in the UK. The Home Affairs Select Committee in Parliament, the Public Accounts Select Committee, the Joint Committee on Human Rights frequently consider aspects of the asylum system. The National Audit Office looks to see whether the country is getting good value for money for the resources it expends. The Refugee Council is very pleased to provide a secretariat for the all-party parliamentary group on asylum refugees, and we work with anybody in Parliament that's interested in finding out more about our perspective. We are but one of a great number of NGOs operating in this space, and no shortage of think tanks, academics, clearly there's plenty of academics in the room today, and the media takes a generally healthy interest in the asylum process. Now the point I'm making, rather laboured I will admit, is that despite this investment in asylum, the experience of most people who come to the UK seeking refugee protection is of a dysfunctional system that struggles to observe the letter of the Refugee Convention, let alone its spirit. I would argue that it's utilitarian and austere in its design, concerned only to provide the basics, to put a roof over somebody's head and a very, very basic level of income, with little or no thought given to the high incidence of traumatisation experienced by people seeking protection, whether that traumatisation occurred in their country, home country, on their journey in search of safety, or on reception in the UK. The system is often harsh and insensitive in its delivery. Use of detention, a rather rough-hewn dispersal policy, and quite stringent reporting conditions. A system in which access to competent legal representation is at best a lottery. And this is important because the system, we would argue, is overly adversarial and hostile, and without a decent legal rep, your chances of a positive outcome at any stage of the decision-making process are limited at best. The system is characterised throughout by delays and by poor quality decision-making, whether on status or on entitlement to support, with over a third of initial refusals by the Home Office of refugee protection overturned on appeal at tribunal. And it's important to remember that you don't really get very far at a tribunal unless you obtain legal representation, which, as I say, remains a lottery. And though officials loathe this expression, and they really do loathe it when we use it, there is more than a hint of a culture of disbelief inhabiting every aspect of the system. And for people who make their way through the system and are given refugee protection, they have 28 days from the day that they're notified of their entitlement to establish themselves independently, whatever their personal circumstances, before they're pushed off a cliff edge and have to survive however best they can. Despite the protestations of ministers and officials, we think it's become a system geared far more to maintaining immigration control than to ensuring safety and providing protection. And when Amber Rudd, the former Home Secretary, stood up in Parliament just a few weeks ago now and talked about the Home Office in the context of the Windrush cases, that her department was more concerned with policy and strategy than with human beings, she could well have been talking about the asylum system. There are good people there, of course there are good people there, and there are pockets of very good practice in the system, but it's not systemic in any way, and it operates in an environment in which the tone is set from on high, determined by the politics of the day. For us, it's difficult to see how critical voices from within the system are ever heard. Whistleblowing, when it happens, is countered by bad apple arguments, and the reality is that those dissidents within the system simply don't hang around. They move out, they find other work, which creates two other problems. The system is constantly in churn and having to recruit and train new people at considerable public expense, and there is very little in the way of any institutional memory about what's worked or failed in the past. The system, I would argue, is underpinned by a self-justifying internal narrative that legitimises the poor treatment of people seeking refugee protection, because on one hand it contends that the system is routinely open to abuse or is abused by people who have no protection needs, and on the other hand that people should be grateful for what they're given the demands they're putting on our state. Indeed, because of the scale of the asylum system, because the scale of the asylum system is very small in relation to overall inward migration flows, roughly 5 to 6% of the total number of people who come here every year intending to stay for 12 months or longer, there is a strong argument to say that while protection remains the responsibility of the Home Office, it will always be overshadowed by border control priorities and the instincts of the Home Office, egged on by a often hysterical media. Put very simply, I can't think of a case, and I've been working in this field for a long time, of any ambitious politician or official who ever enhanced their career prospects by speaking out for refugee rights. What I've described to you is a world that I've known for a long time, as long as I've been working in this field, getting on for 25 years, on and off. But things began to change in 2014 and 2015, as large numbers of people were being displaced across the Middle East and North Africa following the Arab Spring counter-revolution, and from Syria in particular. And significant numbers of those people decided to head for Europe. What was amazing to me was that the old tropes that depicted people who crossed the Mediterranean and made their way to Calais were depicted as economic migrants, not refugees. And these tropes that had worked for so long, very effectively for so long, what amazed me was that they weren't working anymore. They ceased to have their traction and currency. People were demanding, British population, British public were demanding that government, instead of using lazy, callous language like marauding swarms, and saying, this came from the mouth of a government minister, that if we let people drown in the Mediterranean, it would be a humanitarian act, because it would discourage others from getting on boats in the first place. British public said, we're not having that anymore. We want a more compassionate tone. We want government policy to change. Now, why that happened is an interesting area of speculation, perhaps beyond my brief tonight. But I'm going to digress for one moment to say, I think it's because we understood, we as the public, understood from social media primarily, but broadcast media coverage, the story of Syrian refugees. We saw them rising up against a dictatorship. We saw them crushed by what was a very brutal regime. We saw the rise of ISIS. Again, very adept at using social media to get their message across. So when people stepped on mainland Europe, we could put ourselves in their shoes. We knew their story. We could empathise with them in a way that we've never been able to when considering refugees from, say, Afghanistan or the Horn of Africa or sub-Saharan African countries. As a result of these growing concerns, when the photos of the little boy Aylan Kurdi, the boy who drowned, appeared in all our media in September 2015, it was a tipping point. And the government knew it had to respond to public concern. Within days, the Prime Minister, David Cameron, announced that the UK would take 20,000 Syrians for resettlement, and the planning for the programme began. As of today, 2.5 years in, just over 11,000 have arrived and been resettled across the whole of the UK with the cooperation of local authorities and devolved governments, who were also responding to this tide of public concern, demanding that more was done. And this culture of welcome has spread widely and rapidly, drawing in people from all walks of life, evidenced in the rapid growth of the cities of sanctuary and the refugees welcome movements, and the proliferation of new NGOs that have started up just over the last 2 to 3 years. Help Refugees, Refugees at Home, Solidarity with Refugees, RefuAid, Safe Passage, and countless more local groups. The Syrian programme has also generated much civic pride, and in the case of the devolved governments in Northern Ireland, Scotland and Wales, national pride, as well as civil society engagement at a scale we've simply never seen before in this country, with faith groups, trade unions, institutions like universities, schools, even theatres, and latterly, and this is really interesting, latterly businesses wanting to get involved in an issue, refugee protection, that was previously known for its toxicity. 3 years ago, I'd have not believed that the Refugee Council or some of our other peer NGOs would be working closely with Goldman Sachs, or Starbucks, or Virgin, or IKEA. But these kind of connections are increasingly commonplace. And indeed, next week, I'll be attending a breakfast at City Hall, organised by the Greater London Authority and the Mayor's Office, aimed at London-based companies with the aim of promoting refugee employment initiatives, of which there are now many. My concern, whilst welcoming this, is that this welcome environment is yet to bring about the kind of reforms necessary to improve the treatment of and the outcomes for the majority of refugees who make their journeys to the UK and who are not here as a result of resettlement programs. Indeed, in terms of asylum system reform, we still have a long way to go and need to guard very carefully against the emergence of a two-tier protection system where resettled refugees who are brought to the UK, who are given housing and practical support to establish new lives in the UK, are regarded as the good and the deserving refugees, while those who make their own journeys here independently, often along very hazardous routes, are treated as bad or undeserving, even when the decision of the UK state is to give them refugee protection. We support resettlement, of course we support resettlement. We work on resettlement across Yorkshire and Humberside and across Hertfordshire, and it remains one of the UNHCR's 3 durable solutions for any large-scale refugee situation. And we see immense value in the fact that it's a voluntary scheme, as well as being generally well-planned and well-resourced. But resettled refugees in the UK only account for 1 in 4 at best of those given refugee status here every year. And the challenge we face is that the majority of refugees do not get help with accommodation, with welfare, with employment, and with support that they need to live safe, independent, and fulfilling lives. In speeches to the Tory Party conference in 2015 as Home Secretary, and in New York in 2016 as Prime Minister, Theresa May set out a vision of a two-tier protection system. Her words were that we should look to provide for the weak and the vulnerable who were left in the region, and not provide for what she called the rich and the strong who made their own way to Europe. It's a false dichotomy, of course, and thankfully one that's never actually been implemented, not least because claiming refugee protection is a right, making the system completely demand-led, and it's always been difficult to see how the government would ever achieve an aim of reducing the number of people who would come here seeking refugee protection. I think we can look, though, to what Europe's up to, and when acting in concert, Europe has certainly seen some successes in reducing inward flows by the harder policing of our external borders, more concerted removals action, or other extraterritorial action such as the EU-Turkey deal or the Italy-Libya deal. Whether that will lead to a long-term reduction of people entering and claiming refugee protection in country remains to be seen. But the fact is, over the course of the last year alone, the number of applications for protection in the UK has dropped by 8%. What we are calling for is a refugee protection system that is rooted in a culture of respect for individuals, that is humanitarian in its ethos, in its instincts and its actions, but recognises that people fleeing for their lives and who have experienced or witnessed unimaginable horrors need attention to be paid to their mental as well as their physical well-being, and a system that understands and appreciates that the effective integration, inclusion and participation of refugees in our economy, our culture, our communities benefits and strengthens us all. Now, to make that call in an increasingly fractious, dangerous, exploitative, unequal and trigger-happy world may seem fanciful to some. But the one thing I'm not is naive, and the transformation in the prospects for refugee protection that I've seen in the UK over the last 3 years gives me confidence for the future. It's a confidence, though, that's tempered by the fact that nothing in this world, and certainly in refugee protection world, ever happened, nothing good ever happens spontaneously. And that the progress that we've demonstrably been making in recent years has only happened because people have been prepared to argue, to campaign, to lobby, to advocate for change. That a meeting like this has attracted such a large audience gives me immense hope for the future, and I thank the Foundation immensely for the opportunity to come and set out my vision of what is possible. Thank you.
Thank you very much, Morris. I've got the chance to make a few comments myself now, as the names are switched around, and I'm going to. Just for about 10 minutes or so before we open up the floor to questions. And I must say what I found from these presentations was a slightly optimistic tinge I wasn't expecting when I arrived, particularly about the UK, but also I think about Japan here. And I think in question time what we need to do is perhaps kind of drill down into that slightly optimistic vision and ask whether it's kind of sustainable, I suppose, over the long term and what might threaten it there. I think you've given us a very powerful perspective of the different constructions of refugee policies in this country, how regional location, social and political attitudes towards foreigners, attitudes in terms of asylum systems and international law shape somewhat different responses. I think the description of Japan, notwithstanding its those moments you were pushing in a kind of trying to tease out a positive direction, does a very remarkable thing. It makes UK refugee policy look kind of good by comparison. But both these governments and government policies in these countries still share something important in common, I think. They largely construct their asylum practices and policies around deterring arrivals of refugees and preventing them. There's a little bit of an allowance for resettlement, and that in some ways fits with a kind of orderly, managed arrival of people. But as was intimated in your talk, one of the dangers here is that we construct a kind of two-tiered approach where the very availability of resettlement becomes a reason for excluding access to the borders of the UK for those that come on their own accord. We have a classic example of this in practice, and it's called Australia, which has long had, a moderately, quite generous resettlement program, but used as an argument to say that there's a queue for refugee status and people that don't obey it will never get protection within Australia, even to the point where that certainly comes close to violating the Refugee Convention. There are elements here, I think, that move us a little bit beyond perhaps the view that I espoused in the mid-2000s, that what we're seeing here amongst Western states is organised hypocrisy, in the sense that states proclaim the value of asylum on the one hand, and then do all they can to prevent refugees and asylum seekers from staying. But perhaps it's just a kind of modified form in terms of just some very little changes in the realm of resettlement rather than a wholesale rejection of it. We should also remember here that in the background of this, the numbers we're talking about are minuscule compared to, as was rightly said, countries of the global south who are hosting some 2/3 of all of the world's refugees. So whatever tinkering we make with the system here, we have much bigger issues at play once we expand our vision beyond the UK and beyond Japan. Now, both our speakers at the same time clearly feel that Japan and the UK are falling short in some important respects, at least at the level of government policy in their responses to refugees. They may be doing too little in the realm of resettlement. They may be restricting the actual rights of refugees once they're in the country. Their determination systems are questionable, to say the least. And in each case, there seems to be some pressure for a more humanitarian approach coming through here. But before I open the floor for questions, what I wanted to do is to make a few comments on a fundamental question that I think hovers under the surface here, and might prove helpful in terms of contextualising some of this discussion as well. And that's the question of why states should help refugees in the first place. Now, one answer to this is that states have entered freely into legal commitments, particularly under international law, that they would otherwise violate if they didn't. And this obviously is sometimes a very powerful way of criticising government policies. But much of what we're seeing here in terms of what would constitute a better policy, it simply isn't required by international law, and resettlement is a good example of that. There are no international legal obligations to resettle refugees. And I think, and you might expect this from a normative political theorist, but I think the question of why states should help refugees is as much a matter, is as much a moral question as a legal question. And so it matters greatly at the beginning and in public debates how we conceptualise the moral character of this question. And I think one can identify three different grounds for states and perhaps our own as individual moral responsibilities towards refugees. The first, and by far the most common position, locates the duties of states in the idea of rescue. And in this view, refugees are conceptualised primarily just as imperiled human beings. And states, like individuals, are seen as having a humanitarian duty to assist such people, at least when the costs of doing so are low. Now, we can imagine this in our daily lives as well. Imagine, if you will, that a badly injured person shows up on our doorstep one evening requesting help. We have a duty, I think, to help that person, probably by letting them enter the house, ringing services, treating their immediate wounds, at least if we can do so at little cost to ourselves. And this idea, this kind of conceptualisation, this kind of moral conceptualisation of the refugee has a very long history. Virtually all of the world's religions have injunctions about protecting the stranger in need, assisting that stranger. And early theorists of international law, like Grotius and Kant, built these kinds of conceptions into their theories of international law in terms of duties of exiles as well, towards exiles as well. More recently, the political theorist Michael Walzer has grounded the obligation to admit refugees in what he calls the duty of mutual aid, which is a humanitarian duty to assist individuals to whom liberty can't be exported. They can only be helped by moving them to another country. And we might also say that the international law principle of non-refoulement, perhaps the key principle of international law, with its demand that states not turn back refugees who make it to their territory, is a kind of an analogy to this idea of the stranger at the door as well. Now, it's clear that this very common duty of rescue conceptualization has some particular characteristics. First, it's a moral obligation that holds between strangers, and indeed that's what it's about. And secondly, it emerges when someone puts themselves into a position of vulnerability in relation to us, either by arriving at our territory or perhaps by asking for our help. And it's also limited, as I said, by considerations of cost. To take that doorstep example, no one expects that just because we're helping that stranger at the door, we are obliged to make them become a permanent member of our family. But not all refugees, and this is important, stand to us, or perhaps our state, as this kind of unconnected stranger. Some individuals in need are more accurately conceptualised as people that we've had a role in injuring, and our responsibilities towards them, I think, are grounded in a duty to rectify harm that we have done. What if the injured person at our door, to belabor this particular analogy, was someone that we had unknowingly knocked over in a car earlier in that evening. In this case, we'd have a special responsibility to assist them that emerges from the fact that we are implicated in their plight. Now, states, including Western states, perhaps particularly Western states, often have analogous duties towards refugees. A recent case is refugees from Iraq, I think, who've been forced out by circumstances after the US-UK intervention in 2003. And many people would go further and say that the ongoing effects of colonialism or the ongoing consequences of human-made climate change implicate Western states like Japan and like the UK in the generation of refugees. We might see asylum then as a way of repairing the harm done to them by us or by our policies and practice. Now, these duties of harm are not like duties of rescues in some important ways. For a start, they tend to be owed to particular groups of, say, refugees, not refugees on the basis of their humanity. And furthermore, these duties hold wherever the refugee is, whether they're at our borders or not, whether they ask for help or perhaps not. And the low-cost proviso doesn't apply either. We need to compensate those that we've harmed, regardless of costs. That's the principle law courts operate on too, when we are perhaps negligent in terms of our behaviour. Now, finally, we may have obligations to refugees through the international state system itself. And in this view, I think, refugees are conceptualised as our fellow members, in some sense, within a common system of governance. The IR scholar Emma Haddad has recently noted that refugees are the inevitable, if unintended, consequence of the nation-state system. They are the result of erecting boundaries, attempting to assign all individuals to a territory within such boundaries, and then failing to ensure universal representation and protection for such people. So we might say that refugees are people that have been failed by a system as much as they have been failed by their particular countries or governments. And if we value the state system and what it makes possible, this should concern us, because the existence of refugees, particularly on a large scale, and we have around 30 million refugees in the world today, and many more forced migrants, this brings into question whether the state system is itself a defensible way of organising human affairs. Refugees, I think, bring the system's legitimacy into doubt. So we might say that only if states find some collective way of rectifying the system's predictable failures by reincorporating refugees back into forms of membership, can we say that this system genuinely works to promote human interests and warrants the respect of those subject to it. Now, let me just finish. These three ways of conceptualising our moral responsibilities to refugees are not necessarily in tension with each other. We can hold all of them, I think. But they do remind us that this humanitarian conceptualisation of rescue is far from the only way of constructing the refugee and our responsibilities towards those individuals. And I think if we want to look at the kinds of justifications that we need for just the kinds of progressive and inclusive policies that Morris and Naoko have talked about here, we would do well, I think, to draw upon these kinds of arguments from harm and from common membership, as well as from this idea of rescue, in the way that we think about refugees.